Through a series of interviews with the applicant, respondent, and judges, we will explore the judgment in Killer Queen LLC versus Taylor from the full federal court. We hope you enjoyed this clip.
Katie, can you tell us how this dispute began?
I started my fashion business in 2007 using my own name, Katy Perry. I had no idea there was an American singer with a similar name. I registered my trademark, Katy Perry, in Australia in September 2008 for clothing, completely in good faith. I was just a small Australian designer trying to build my luxury loungewear brand.
When did you first become aware of Katy Perry, the singer?
I first heard about her in July 2008 when I Kissed a Girl came out. But by then, I'd already invested significant time and money into my brand. I'd registered my domain name, katyperry.com.au, back in May 2007, well before I knew she existed.
What's your position on the trademark infringement claims?
Katy Perry and her companies deliberately infringed my registered trademark. They knew about my registration from 2009, but continued selling clothing with Katy Perry on it in Australia anyway. They took a calculated risk and chose to ignore my rights. They should have respected my prior registration or worked out a proper coexistence agreement, which I was open to discussing.
How do you respond to their argument that they were just using her own name?
The own name defense has limits. She assigned her trademark rights to her company Killer Queen in 2011, so she wasn't even the owner anymore. Plus, she was using an adopted stage name, not her legal name. And her companies like Killer Queen and Kitty Purry certainly can't claim they were using their own name.
How does Katy Perry's team respond to these infringement claims?
Katy Perry has been using her stage name professionally since 2002, years before Miss Taylor started her business. She's an internationally famous artist who built a global reputation under that name. She was simply using her own name in good faith, the name she's known by worldwide.
But Katy Taylor registered her trademark first in Australia. Doesn't that give her priority?
Registration alone doesn't end the analysis. We have several defenses. First, Katy was using her own name in good faith. She genuinely didn't believe there would be any consumer confusion between her international pop star merchandise and Miss Taylor's small local fashion business. Second, we argue that Taylor's trademark should never have been registered in the first place because of Katy's prior reputation.
Can you explain the reputation argument?
By 2008, Katy Perry was already an internationally famous pop star with a significant reputation in Australia. Her songs were on Australian radio. Her albums were charting here. It's common for music artists to sell clothing merchandise. Everyone knows that. Taylor's mark should be cancelled because its use would likely confuse consumers who associate Katy Perry with the famous singer.
What about the joint tortfeasor claims against the various companies?
The primary judge was too restrictive in finding that only Katy Perry was liable as a joint tortfeasor with our merchandising partners, like Bravado. Katie Hudson was intimately involved in approving merchandise designs and had contractual obligations that went beyond just being a director. She should be recognized as acting in concert with the merchandising companies, not just facilitating their actions.
Your Honor, this case involved complex issues of trademark law. What were the key legal questions?
This case required us to balance several competing interests: the rights of a local trademark registrant versus an internationally famous entertainer, the scope of the own name defense, and, most importantly, whether the registered trademark was validly registered in the first place.
You ultimately found in favor of Katy Perry on the main issue. Can you explain why?
While we found that trademark infringement did occur, both Katie Hudson personally and her company Kitty Purry infringed Taylor's registered mark. The crucial finding was that Taylor's trademark registration was invalid and should be canceled.
What made the trademark registration invalid?
Under Section 60 of the Trademarks Act, a trademark can be opposed or canceled if, because of reputation in a prior mark, its use would be likely to deceive or cause confusion. We found that by September 2008, when Taylor applied for her mark, Katy Perry already had significant reputation in Australia as an internationally famous pop star using the name Katy Perry.
But the primary judge had rejected this argument. What did she get wrong?
The primary judge made several errors. She artificially separated Katy Perry's reputation in entertainment from any potential reputation in clothing. despite evidence that pop stars commonly sell merchandise. She placed undue weight on the absence of actual consumer confusion, which was explained by Taylor's limited business scale, and she focused on post-2008 differences in how the marks were used, rather than the proper legal test.
What about the own name defense?
We upheld that Katie Hudson could rely on the own name defense for her personal acts of infringement. A person can use their stage name if that's how they're genuinely known. However, her companies, like Killer Queen, couldn't rely on this defense. They weren't using their own name.
How did you handle the discretion about whether to cancel the trademark?
Even though Taylor adopted her mark innocently, by the time she applied for registration, she knew about Katy Perry's fame and that celebrities commonly sell clothing merchandise. This knowledge contributed to the situation that led to the Section 60 finding. The public interest in maintaining a pure trademark register outweighed any hardship to Taylor.
What's the ultimate outcome?
Taylor's trademark registration will be canceled. The infringement findings become moot since there's no valid trademark to infringe. We've stayed our cancellation order pending any high court appeal. While this may seem harsh on Taylor, who genuinely adopted her own name, the law must protect against consumer confusion and maintain the integrity of the trademark system.
Well, that's all we have for you. We hope that you have enjoyed this clip and look forward to seeing you again soon.